another episode of Anderson TV. I'm Josiah Anderson. So today we're going to talk about Trump's battles with these federal court judges, lower court federal judges, and vice versa. So today we're going to talk about Trump versus the courts. So anyways, we've been seeing all these injunctions that Trump would get from these federal activist judges, most of them from the Biden administration, the Obama administration, Bush administration, some all the way towards Reagan administration. And liberal media would love to say that, oh, some of those judges are from Trump's first term. You know what? They are. But apparently some of these judges could be biased. Some of these judges could be bought and paid for, like a district attorney, some lawyers, or something that matter. These people can be bought and paid for. So anyways, like in New York, for example, so you have Letitia James, the Attorney General in New York, and Manhattan DA Alvin Bragg were both bought and paid for by George Soros. You know, George Soros would purchase these prosecutors to be soft on crime rather than hard on it. So we're going to talk about activist judges and something from the Heritage Foundation that I found very interesting. And this seems like a very good idea from the Heritage Foundation. We're going to talk more about that in this episode. So anyways, I checked out this very good document from the Heritage Foundation, but since that some of you guys won't probably understand what it says, so I went to ChatGPT and made a summary out of this document. So anyways, what are the problems with these activist judges? So we have like 4 problems here. So the first one is constitutional overreach. So Article 1 gives power to Congress. Article 2, the president. Article 3 limits judicial authority. So what the Heritage Foundation's document contends is that activist judges are violating Article 3 by effectively making laws via court rulings. It emphasizes that court judgment should only apply to the parties involved, not nationwide. So, you know, Article 3 says it limits judicial authority. So, probably most powerful branches is that of the president and Congress. So, number 2, the misuse of nationwide injunctions. So, these injunctions are considered illegitimate expansions of judicial power. Courts should not bind non-parties to litigation, which is what nationwide injunctions effectively do. So, number 3, encouragement of judge shopping. Plaintiffs strategically file cases in districts likely to produce favorable rulings, a practice referred to as judge shopping. This undermines fairness and gives an impression of a politicized judiciary. So, I know more about that. So, you notice how all of the news reports say a federal judge in Massachusetts, a federal judge in Delaware, a federal judge in Washington State. Notice all of those are blue states. Notice that they're making these rulings in blue states. So, which means that they are most likely to produce a favorable ruling in favor of the plaintiff against President of the United States. And number 4, erosion of judicial credibility. The public may lose trust in judicial impartiality if courts are perceived as politically motivated. So, anyways, what these judges are doing, they're playing politics. So, like for example, sabotaging Trump's efforts to do something about this illegal migrant crisis going on in this country. So the courts are stopping him from doing so. First, they tell him to stop these deportations. Don't deport this person. Don't deport that person, or something that matter. Who did we elect to be president of the United States? Those lower court judges or Donald J. Trump? Who do we elect as president? So, exactly. So, probably some of these rulings that these judges are doing, it is ridiculous and should be held accountable to the fullest extent. So, Heritage Foundation, they came up with some solutions to these issues. So, they came up with 3 options. So, one is centralizing legal challenges. All lawsuits challenging the constitutionality or legality of executive orders or federal regulations should be filed exclusively in the District of Columbia's Federal District Court. Justified by comparison of the Voting Rights Act of 1965 with centralized legal challenges in the same court. These cases could be heard by a 3-judge panel, enhancing review quality and reducing bias. Now, when I saw that, it's a great idea. Very smart idea. And this should be going on for the rest of these lawsuits that they have against the Trump administration or something that matters. So they should have it in the District of Columbia, Washington, D.C., where most of this administration work in. And not should be filed in blue states or red states, whether you want to call it, because I know that there will be some Republicans that want to do the same thing, but we have to hold both parties accountable for this. So, in the 3-judge panel thing, that's a great idea, because usually when you have like a multiple judge panel, of course, that you definitely want to hear their opinion on it, on this lawsuit or something like that, so that they will actually review it. So the second solution is reforming the standard of review. Proposes altering how appellate courts review injunctions, especially those broader than necessary, and calls for stricter appellate scrutiny of sweeping nationwide injunctions. Exactly. So, especially these courts review injunctions, there should be accountability in how they review these. So, if you create a nationwide injunction, because the president, of course, is supposed to be like transparent with people, so why can't the courts be more transparent? Why can't these appellate courts be more transparent? So, and some legislative actions. That's the third thing. Highlights 2 congressional bills inspired by Heritage recommendations. There is one, the House, the No Rogue Rulings Act, Representative Darrell Issa. It requires nationwide relief requests to be handled by a 3-judge panel with direct appeal to the Supreme Court. So, that's a great idea. So if any plaintiff want to file a lawsuit with like what the president's doing on foreign policy or something like that, those requests should be handled by a 3-judge panel, which is a very good idea. Because you never know that one judge could be biased, and they would immediately make a ruling because of their hatred for Donald Trump. That they want to make that ruling because of their hatred for Donald Trump, or they have some skeletons in their closet, or they're probably hiding illegal migrants, or they probably support this movement, they support that movement, or something of that matter. You know, probably many years ago, if someone showed a bit of bias against like a criminal case or some sort of court case or something like that, they would probably recuse themselves from trying that case and instead let it be tried by an unbiased judge. But unfortunately, since the plaintiffs want to try these cases in majority blue districts, which they know they are going to get a fair shake. So, anyways, that is that document for the Heritage Foundation. Now, I found something very interesting. Found a very interesting Supreme Court case from 1867. And so it's called Mississippi v. Johnson. So search it up and see for yourself. But just going to read out the information here. So Mississippi v. Johnson, 1867, was a landmark Supreme Court case that significantly shaped the understanding of the separation of powers and executive immunity in the United States. The facts of it. So in 1867, Congress passed the Reconstruction Act, which divided the former Confederate states, except Tennessee, into military districts and imposed military rule until new loyal governments could be established. President Andrew Johnson, who had vetoed the act but was overridden by Congress, was tasked with their enforcement. The state of Mississippi, opposing the Reconstruction Acts, sought to prevent President Johnson from enforcing them, arguing they were unconstitutional. Mississippi requested the Supreme Court issue an injunction, a court order to stop an action against the president. The issue, could the Supreme Court issue an injunction against the President of the United States to prevent him from carrying out his official duties, specifically enforcing acts of Congress, even if those acts were argued to be unconstitutional? Now, the holding, in a unanimous decision, the Supreme Court ruled it did not have the jurisdiction to enjoin the president in the performance of his official duties. The court held that the president's duties in enforcing the Reconstruction Acts were executive and political, involving discretion and judgment, not purely ministerial duties which might be subject to judicial oversight. So, the reasoning, the court reasoned that interfering with the president's performance of executive duties would violate the separation of powers doctrine, risking a collision between the judicial and executive branches of government. It emphasized that the president, in carrying out his official duties, is immune from such lawsuits. The court noted that while the president can be held accountable for high crimes and misdemeanors, this is through the impeachment process by Congress, not through judicial injunction. So, now the significance of it. So, Mississippi v. Johnson established the principle of executive immunity for the president from judicial intervention when performing executive and political duties. This case was crucial in defining the boundaries between the branches of government and upholding the independence of the executive branch in carrying out its functions. It clarified that the Supreme Court can review the constitutionalities of laws, but generally only after they have been enacted and put into action, not by attempting to restrain the president from enforcing them. So, yeah, that is what the Supreme Court has ruled. So, anyways, this is basically saying that so the president cannot be sued to prevent him from enforcing laws through political and executive functions. So there is executive immunity. So, anyways, what these activist judges are doing is going against Mississippi v. Johnson. I mean, I don't know. I'm just reading from all of this, so So all I know is that, yeah, these judges are activists. They're called activist judges for a reason, because that they want to sabotage the Trump administration's foreign policy agenda, domestic policy agenda, and everything of that matter. Even though that some presidents before Trump probably did some of the same things, and they didn't get any injunctions. I mean, they were doing deportations as well, but none of them received an injunction. So this is attack. This is an attack on one man by multiple activist judges. Excuse me. So yeah, this is an ambush on the second Trump administration. This is exactly what this is. It is an ambush. Now, I have to admit that there will be some things that the Trump administration might get wrong. And the Supreme Court might rule, they might rule against some that the Trump administration might have done. I mean, no administration is perfect. And I don't expect this administration to be perfect either. It's just how it is. I mean, we can't put all of our trust in these politicians. We can't put all our trust in the three branches of government. We can put some of it in it, but sometimes you're going to have to watch out for a little bit of bias. So, anyways, we'll be right back. So that is it for this week's episode. So I am still working on the book Brainwash, and this week's episode, the 47, will be Warren G. Harding and Calvin Coolidge. That'll be for this week's the 47 episodes. So anyways, I keep hearing all kinds of good news about everyone. Congratulations if you got into another year of college, or gotten into college, or something that matters. So congratulations. So anyways, I don't know what I'm going to be doing after season 36. So realize that politics would be a very tough subject to talk about sometimes. I'm not taking a break from it or anything of that matter, because there's a lot of controversies that go along with it. So anyways, don't forget. So I will keep you guys updated on my book and the 47, and as well as more episodes of Anderson TV. Now, about doing an Instagram Live, I'm not doing that. So I don't think that this is probably the place to do that, to do those Instagram Lives. So, but if I were to do one, then who would show up? And in case you're wondering about Reddit, yeah, I was on Reddit, but I Understand TV is no longer on Reddit because this is practically because Reddit is a predominantly liberal application full of liberal extremists. It is full of liberal extremists who want to go after me, even, albeit my time of desperate need. So I'm no longer using Reddit anymore. So anyways, if you try to see me on Reddit, then I will not be there. So, alright, so that is it for this episode. I'm Josiah Anderson, signing off. Goodbye, everyone.